Sveicināti godātie viesi, godājumie dalībnieki.
Good morning, honorable guests, those participants who are in person and those who are watching us remotely. Before we start the content of the conference, I would like to draw your attention to technical things. So I believe and I hope that those of you who need interpretation, you have downloaded the Linearis Interactive app, because we will ensure the interpretation and you can get it through this interactive app. And the code of this event, the title is New Fuel for Business, and BHR 2010-24 is the code. Thank you very much to our cooperation partners, also the interpreters and that pseudo translation is also ensured, because it is very important when we speak about business and human rights. It's very important that those events are accessible to everyone. And with our example, we wanted to prove that all the events are accessible to everyone, both in terms of language and also in terms of being able to come here with a wheelchair, and also to ensure all the types of translation. And also thank you to our wonderful colleagues from the Tiešraide team. They will help us online here and also remotely. Just a short time ago, when we think about the topic business and human rights, and when we some years ago talked with an ombudsman whether this topic is topical for us, and we thought, no, not in Latvia, everything is good. Maybe we are talking about some remote countries. We were thinking when we, for example, when we are purchasing coffee or chocolate, then this is binding for other countries far, far away. And then now we see that this idea was actually faulty. And what is the best is that you are able to recognize your mistakes. And so we are happy that we have grown in our understanding that also in Latvia, the topic about human rights and business is very topical. And also in the Ombudsman's office, this is like a new era, and we see a lot of potential in it. And thank you to those of you who have devoted your time and you're interested in this topic. And this event wouldn't be possible without our cooperation partners. First of all, the hosts, our partners, the Riga Graduate School of Law. Thank you very much. Also, thank you to the Nordic Council of Ministers in Latvia, and also the partners, the Danish Human Rights Institute, without whom this event wouldn't be possible. So that's all. Thank you very much. And now I will give floor to the rector of the Riga Graduate School of Law, to the rector Adam Chernot, for the welcoming speech.
As was mentioned before, my name is Adam Chernot. I am rector of RGSL. So on behalf of RGSL, welcome to this conference. The topic of this conference, for me at least, is extremely intriguing, right? It means relation between human rights and business is always complicated. And it seems to me, I'm looking forward to the discussion. It means that human rights as fuel for business is something which, it seems to me, should be really deeply explored here. And I welcome especially representative of the co-organizers of this conference, namely the people from the Office of the Ombudsman of the Republic of Latvia, and also representative of another co-organizer, the Nordic Council of Ministers office in Latvia. I won't speak long, but I am not a human rights lawyer. I am not a business-oriented person. But I am a socio-legal scholar. And one of the biggest social theorists, Jürgen Habermas, reminds us that law possesses Janus double face. It could be used as a sword and as a shield. I understand that the role of the institution of Ombudsman is to work as a shield, actually to defend people. Human rights also play the same role. It means the role of defending the rights of citizens, of individuals. Business, on the other hand, as you know, is quite often, according at least to the social theorists, is involved to a high degree in the colonization of something which they called life world. So it means to me, combination of both it could be an extremely important research area and topic for the discussion. I wish you a fruitful discussion, and I am looking forward for the exchange of ideas. Welcome.
Paldies rektoram.
Thank you very much, Director. I forgot to mention one very important aspect. Thanks to Tilde, we also have transcripts. So for those people for whom it's easier to read the text, also this opportunity and this possibility is provided. Thank you for the opening and keynote speech of the Rector. And now I would like to ask Mr. Mārtiņš Birģelis, my colleague. He is one of the wisest people in Latvia. So Mārtiņš, please, the floor is yours. Good morning, ladies and gentlemen, all who are present here, and also all of those who are watching us online. My name is Mārtiņš Birģelis, and I am really honored and happy to be here today in this conference. And this conference is about my very beloved topic, human rights and business. I would like to draw your attention to two principal things right now. So how companies impact human rights, and what is this field? So human rights and also business. So how we started discussion. So I would like to start that human rights are rights that each of us possess just because we are humans. And those rights ensure a human life for us and human dignity. Business, on the other hand, is a wonderful tool that allows us to implement those rights. So entrepreneurship, business ensure workplaces, ensure rights to work, also provide goods and services that are needed for us on a daily basis to ensure our health and other basic needs. And also it increases the welfare of the state. So it means that it ensures also primarily the social, economic and cultural rights. And of course, we also have to notice that getting profit is the basis for entrepreneurship. And that has led us to the situation where international society was shaken because it ended up with tragedies where companies were involved. About, for example, gas tragedy in India and also Zolito, the tragedy in Latvia. But on a daily basis, there are also more direct ways how companies and businesses impact human rights, and it's at several levels. First of all, businesses have power over their employees and how they use and employ and use their rights, and also over customers. Second is that companies control access to certain resources, whether this is to finances, land, or environment. And third, considering the political influence of businesses, large businesses can impact decision makers in their favorable way, promoting the favorable policies for them that are not always in line with human rights interests. And finally, businesses also have a possibility directly influence the opinion of society and direct it towards the benefit of the companies instead of benefit for humans and individuals in general. So we can see that there are a negative impact of one human rights and with other. For example, one example from Latvia. In February, investigative journalists published the story about one very popular company in Latvia that manufactures milk products, dairy products. And this story, which was really very shaking for us. We heard that, for example, people are employed 300 hours a month, and so the most vulnerable employees, refugees from Ukraine and young people, very often they find themselves in situation that they, in some way, they get some accidents, lose some part of their body, finger or something, and they don't receive any support because those employees are instructed to act in a certain way, not in line with their interests. And so all this introduction was in order to say that this sector, this sphere, business and human rights, was created for the reason to understand how companies, how businesses impact human rights and how to reduce this negative impact. And even though there is a kind of hard to understand when we started to discuss this topic, but I think we are quite clear that in 2011, when the UN Basic Principles of Human Rights were approved, this was like a cornerstone, and it provides for us a very strong framework how to look at those issues and problems. And if we look at the further development and how it developed later, you will hear from the experts later. But I would like to note that John Ruggie, when he presented those principles, he acknowledged that this is not the beginning of the end. More precisely, he said this is the end of the beginning. He said this is the beginning for you, how to understand, how to start acting, but now it's your job to implement those principles. And here I would like to use the opportunity and also to say thank you to the Ombudsman's office, that those principles are also available in Latvian language. Today it might seem like normal, but it wasn't like that for a long time. And so thanks to the Ombudsman's office, and we can talk about those terms in our united language, in our state language, and we can create a dialogue with the decision makers, businesses, and also representatives of the community. I also would like to highlight my own opinion that I have gotten because of my research. So it is clear that only business that is in line with human rights, this is sustainable and long-term business. So really, human rights is the new fuel, and companies have to take care so they don't lack it. So thank you very much for your attention.
Thank
you very much to Mārtiņš. So Mārtiņš is a scholar at the University of Latvia, but he is also legal advisor of our parliament, so I didn't exaggerate. You are very, very smart. But now I also would like to ask our cooperation partner, Gabriel Holly, who is the chief advisor for Danish Institute for Human Rights. So Danish people are one of great examples we could follow. So Gabriel, please, the floor is yours.
Great. Thank you very much, and thank you so much, Martins, for your introduction. I think that the discipline of business and human rights and human rights in general can often be quite abstract and hard for people to understand. So the examples you give, I think, help make it much more concrete for everyone in the room to really understand how businesses can impact on human rights. So thank you for that. So with Martin's good scene setting, I'll speak a little bit about this trend toward regulation in the area of business and human rights. And here we see some quite clear trends, particularly at the EU level, where quite a lot is going on at the moment. So I'll give you a quick introduction of how do we get here, how do we come from the UNGPs being adopted a little over a decade ago to now being in a time where there is an increasingly complex regulatory environment for businesses to navigate. And then I'll give you a quick overview of that regulatory environment. So this slide just gives you a little bit of an indication of the evolution in this area. from the adoption of the UNGPs and OECD guidelines, which are the two kind of main authoritative standards that we use in this area, each of which set out this process of human rights due diligence. And we see sort of that kind of, they were adopted a decade or so ago, but from there we see this sort of evolution toward this development of policy commitments. We see the commitments toward business respect for human rights and the process of human rights due diligence finding its way into EU CSR communication. We see a number of states developing their own national action plans on business and human rights, so how to implement the UNGPs in the national context. And we also see a number of kind of early adopter companies starting to develop policy commitments to respect human rights and commit to a process of due diligence. From there, we see this sort of development of disclosure obligations, and they were the kind of like the proto-regulation in this area. We see obligations to disclose on non-financial matters in the EU through the Non-Financial Reporting Directive, which require companies to disclose on matters including how the company impacted on human rights. And that's now been evolved into a new regulation, the Corporate Sustainability Reporting Directive, which has quite granular sustainability reporting standards associated with it, which really require companies to engage with due diligence, think about what impacts they have on people, and report on that. So from the reporting obligations, we then started to see the development of national mandatory human rights and environmental due diligence laws. The first of these came in France in 2017, which required companies to develop what were called vigilance plans, which set out how a company was going to kind of essentially do due diligence. Recently, we've seen laws in Germany and Norway. And so, again, you have these legal requirements to undertake a form of due diligence in line with these legal standards, very much informed by the process of due diligence outlined in the UNGPs, which you'll hear about a lot today. And I've got here a little box saying, and the EU Corporate Sustainability Due Diligence Directive is coming. That now is a little bit more uncertain. I don't know how many of you in the room have been following the developments in the last few weeks around the directive, but there was an intention to create an EU-level directive requiring companies to undertake mandatory human rights and environmental due diligence. That agreement now hangs in the balance, and we might see an agreement coming in this week, or it might not materialize at all. But again, it's a little bit uncertain, but we'll nonetheless cover its main elements in the presentation today. So I won't dwell on this because you'll hear about the UNGPs at length today, but just as a reminder that they contain 3 pillars. Pillar 2 contains this responsibility on business to respect human rights, and which is largely discharged by undertaking human rights due diligence. But what we'll focus on a little bit more in this presentation today is Pillar 1, the state duty to protect human rights, which is essentially done through enacting and enforcing laws. Again, this is the responsibility of business to essentially conduct human rights due diligence. I won't dwell on this slide because other speakers will speak to it in detail, but there is this kind of ongoing, continuous process of due diligence, which has, in this slide, 4 stages. You'll see it sometimes depicted in 6 stages, 8 stages. Whichever way it is depicted, as long as it contains the main elements, we're good. So, under Pillar 1, states are required to protect human rights, and this is primarily done through enacting and enforcing laws. And laws regulating business impacts on human rights can take a huge range of forms. Indeed, there are already a range of laws that will be enforced in your jurisdiction, which will, in some ways will regulate how businesses impact on rights, whether that be labour laws, whether that be environmental protection laws, consumer laws, prohibitions on certain conduct that causes harm, that sort of thing. So there'll already be a legal framework which certainly impacts on how businesses can impact on human rights. But nonetheless, we are seeing this trend toward the introduction of these mandatory human rights and environmental due diligence laws, which essentially take this process of due diligence outlined in the UNGPs and create a legal obligation, what we often term the hardening of soft law. So I put this slide up here not to talk you through it in any detail, and I think it will be too small to really see in any detail. But this is quite a useful graphic, and I'll make sure that the slides are shared with participants afterwards. It's a graphic created by the World Business Council on Sustainable Development, and it's these concentric circles which start at the beginning with that green dot, which has the adoption of the UNGPs. And I put it here not to kind of talk to the content so much, but to just graphically show this explosion of different kinds of standards, national action plans, laws, regulations, guidance documents in this area that have happened since the adoption of the UNGPs at the centre here. Now, this graphic only goes up to 2020. And I think, honestly, if they were to maintain this graphic, they would really struggle, because in the last few years, there's been, I think, an even greater proliferation of different kinds of standards, laws, national action plans. And I pulled out a couple of the sort of the main legal developments here. Again, I won't discuss this in too much detail, but really just to use this slide to show that there has been this kind of extraordinary trend in the development of regulation in this area. And you see the number of dots starting to increase over time. So what we have in here is sort of laws that relate to sector or commodity-specific initiatives. So we see laws regulating mineral supply chains to address human rights abuses associated with conflict minerals. We see issue-specific initiatives, so those focused on, for example, issues of modern slavery. There have been sort of modern slavery-specific laws in the UK, in Australia. There's been a child labour law in the Netherlands, although it hasn't come into force yet. And so there's been a kind of a number of regulations which focus on a specific issue. There's also been laws around non-financial reporting, which I touched on earlier. So we had in 2014 at the EU level the Non-Financial Reporting Directive, which has been kind of revised and revamped as a corporate sustainability reporting directive now, which is just being transposed and requires a much more kind of granular level of engagement of businesses with their human rights impacts. We see initiatives on sustainable finance as well, so how financial institutions should be identifying and assessing how they impact on human rights. We also see a development at the international level and efforts to create an international treaty on business and human rights. It's happening in parallel with all these national and regional level legal developments. And then, of course, we have mandatory human rights and environmental due diligence laws, which I will speak to now. So this is a slightly challenging initiative to talk about at the moment, because it is a little bit uncertain. We don't yet know if this law is ultimately going to come into force, but it has been under development for the last 4 years. It looks as though there is a last chance to create some kind of agreement on this this week, so we're hopeful that this will find its way into law. But essentially what this EU initiative would require is it's mandatory human rights and environmental due diligence law with some corporate governance aspects that have largely been taken out through the negotiation period. It will require large companies and certain medium-sized companies, both EU and non-EU, to undertake due diligence on a range of human rights and environmental impacts. The process of due diligence outlined in the directive generally aligns with that in the UNGPs, but of course with some modifications, because if you have an instrument like the UNGPs, which is a soft law instrument, it was never designed to be a legal instrument per se, and so it requires some kind of modification to kind of make it make sense in a legal context. But there are some departures which we can talk about maybe in the break. But this is one part of a much kind of broader European regulatory ecosystem. So in recent years, there have been a range of regulatory initiatives which in different ways seek to regulate the impacts that businesses have on the enjoyment of human rights. We have a publication here called How Do the Pieces Fit in the Puzzle? Making Sense of EU Regulatory Initiatives Related to Business and Human Rights, which we'll share a link to participants. And that kind of maps out the various EU regulatory initiatives that in some way regulate business impacts on human rights. I pulled out a couple of initiatives here, but the publication is much broader. So it also includes tech and digital ecosystem-related initiatives, green transition-related initiatives like the Critical Raw Materials Act and the Batteries Regulation. I'll leave those aside for the moment just to focus on some of the core pieces here of the regulatory ecosystem. So we have this one bucket here, which is company-focused initiatives. So we have the Corporate Sustainability Due Diligence Directive, fate unknown, but there's nonetheless a very important piece that is cross-referred to in a number of the instruments that are outlined in this slide. We have associated with that the Corporate Sustainability Reporting Directive, which I've mentioned a couple of times, which requires companies to report on, among other things, their due diligence processes. We have a number of initiatives focused on sustainable finance. So we have the Sustainable Finance Disclosure Regulation, which does, as you might expect, require financial institutions to disclose on a range of matters, including the human rights impacts of their investments and their activities. We have the Green Taxonomy, which is an initiative to create essentially a classification system for economic activities to assess whether or not they contribute to certain environmental objectives. And as a component part of that, in order for an economic activity to be what we call taxonomy aligned, it also needs to, the entity undertaking the activity needs to adhere to the UNGPs and the OECD guidelines. So there's also a kind of a social component incorporated into the green taxonomy. And essentially the logic of that instrument is to try to direct finance flows toward environmentally sustainable economic activities through this classification system. And then we have another bucket here, a number of trade and import controls. We have the forced labour ban, which was in trialogue, but an agreement was reached earlier this week on that initiative, so that looks like it will become law very soon. That is essentially a prohibition on importing goods produced, on goods produced using forced labour entering the EU market, whether they come from outside or inside of the EU. Then we have a number of more kind of commodity-specific initiatives or issue-specific initiatives. The deforestation regulation, which places due diligence requirements on importers of certain commodities to assess whether or not they contribute to deforestation. That also has a kind of a social human rights component. We have the timber regulation, which some of you may be familiar with. It's the earliest of the regulations on this slide, which kind of, again, requires a due diligence to be conducted on timber products. And the conflict minerals regulation, which is, again, structured quite similarly to the timber regulation, requiring due diligence to be conducted on certain kinds of mineral supply chains. Essentially, the timber regulation, the complex minerals regulation are less due diligence laws proper, but more of a kind of reporting obligation, essentially. So you undertake due diligence, but then you sort of you report that the goods that you're importing meet certain standards. So we have this kind of increasingly complex regulatory environment where each of these measures are sort of essentially directed toward the same objective, to ensuring business respect for human rights, but they do it through different ways, either through so the CSDD introduces a due diligence obligation on real economy and financial sector entities, sort of, which requires the undertaking of due diligence and real engagement with how the company impacts on people and planet. The disclosure obligations under the CSRD and the SFDR address disclosures, and so again are a softer way of trying to drive business conduct by requiring them to essentially kind of know and show what kind of impacts they have on people and planet, which helps accountability, helps stakeholders understand how companies are dealing with these kinds of impacts, and allows them, regulators to also kind of oversee companies properly. They interrelate because financial actors will rely on the information from the real economy companies disclosed under the CSRD to meet their obligations under the SFDR. And then we have import controls, which in various ways try to restrict access to the EU market if certain human rights and environmental criteria are not met. So again, all of these initiatives essentially driving toward the same point, but attack the problem from different angles. But nonetheless, there is a kind of need for regulatory alignment here because all of these various initiatives have developed at a slightly different pace. Some of them are at a different stage in the legislative process. Often these initiatives don't speak to each other as well as they might. And so there is, nonetheless, even though there is, I think, an appreciation on behalf of European legislators that there is a need for policy coherence, sometimes that isn't the case. So there is, I think, a real need to help business navigate this increasingly complex regulatory environment. We'll speak, I'm sure, a lot more about these issues in the course of the day, but I'll leave it there and hand over to the next speaker. But thank you.
Paldies mūsu Dānijas cilvēktiesību institūta vadošai padomniecei Gabrielai Folijai, kas deva mums ieskatu tajā vēstures
senior advisor. She provided historic information on the development of this concept. I would also like to invite not only to look at the historic aspect, but also to look at the Latvian examples, good examples from Latvia, because we have good examples in Latvia. And now I would like to invite Evita Gosha, the member of the board and the director that deals with environmental issues. I never want to claim that I am as clever and as intelligent as Mārtiņš, but I will do my best. This was a joke, of course. Thank you for invitation. I'm very honored to be here. I'm happy to see known faces here, someone with whom we have cooperated what concerns sustainability, but I also see unknown faces with whom I would like to cooperate what concerns diversity and human rights, and I hope that this will be an inspiring invitation. Though in Latvia we have various formal and informal sustainability cooperation networks, we still can do more. We can learn each from other, and we can grow together. But now I would like to tell about the practice of my company. In April, I will celebrate the 16th anniversary since I have worked in our company, not only because it's interesting, but also because the values of this company are aligned with my personal values, and I am proud and honored to contribute to the corporate culture where people can implement their potential, because I truly believe that people can do that only in circumstances when they feel included, valued, and that their opinions count, and that they are heard. It is very important to create proper corporate culture in a company that allows to implement various procedures and policies. But first and foremost, you need a culture that really demonstrates what is corporate values. And in Latvia, we have our internal document, which I call our constitution, that outlines our main operational principles, including human rights, employment and diversity section. And this code of ethics clearly states that everyone is valuable, irrespective of gender, ethnic origin, sexual orientation, and so on. All of our employees, all of our cooperation partners, persons, individuals are valuable, and only professional capacity determines how we can cooperate. And then, of course, there is a range of instruments and policies that allow us to implement these values in life in detail. Of course, I will not be able to explain everything what concerns employees, cooperation partners, suppliers and vendors. But the main things that I would like to underline is that openness, cooperation culture allows us to find out about the needs of our employees and cooperation partners, and we use various formats to achieve that. For example, all managers, irrespective of whether they are board members or middle-level managers, they need to visit all of our sites because we have various quarries and production facilities, including far away from Riga, where people may feel quite isolated on a daily basis. Thus, it's very important for us to maintain this principle that we are one company. Today I am here in this suit, but maybe tomorrow or after this meeting I may go to for an on-site visit. And I have had these situations when I have visited the president's palace, castle, and then immediately after that I have put on my rubber boots to go to a quarry. So we have to avoid hierarchies that prevent us from speaking, because when we speak with people, we find out unimaginable things about how they feel, what problems they have that we could never imagine. When we sit in our office and have our cup of coffee, and coffee is, by the way, very important, because in all of our sites, even the smallest sites, we have coffee machines, and this is very, very important. It seems a minor thing, but if you drink coffee and if you don't have a cup of coffee in the morning, just imagine how you feel. Probably not good. Yes, maybe it's a minor thing, but it is still very important. We give our employees the right to make decisions. Quite often, as we are producers of specific products, that the customers are always right, but this is not the case. If the customers' conduct endangers the safety of our employees, then the customer is not right. For example, when we deliver our concrete to the customer's sites, if the customer is unable to meet specific safety requirements set out in the laws and our requirements, then our employees have a clear instruction that though there could be grounds for dispute, the employee has the right not to endanger him or herself and return to the production site. So we create this engagement culture where all employees feel that they are also responsible, that they own this process, and then we have good ideas. We have a system where employees and suppliers are invited to report potential risks or improvements what concerns in the working environment or procedures or processes. And these suggestions are also linked with the bonus system. People are interested in improving the employment environment, and these improvements can generate thousands of recommendations. We also have very many suppliers, for example, what concerns logistics. If you see these concrete trucks, for example, on the Liepāja highway, these are our cooperation partners. And these are drivers that drive these trucks, and we use subcontractors not to rid ourselves of responsibility, but we still feel responsible for these people. We have a special employee, a designated employee, who makes sure that subcontractors comply with employment law, with rest time requirements, and we have spent years on trying to make sure that all taxes are paid, that the drivers have good working conditions, we train them, and there is a whole range of procedures, including safety requirements in trucks. For example, they need to meet higher security requirements than set out in the law, for example, what concerns technical inspections. There are also other measures that would make them feel safe, and I could continue for a long time, but I have to say that I'm really convinced that there is benefit in making sure that everyone is included. Of course, there could be moral issues, but there are also practical issues, because when we comply with all of that, it's just pragmatically beneficial, because we never want to end up having lengthy legal battles. We don't want bad reputation. We want good employees. For example, our turnover is 5 5%. And some say that this is a dead organization, but this is due to the fact that our employees feel really good. They don't want to go somewhere else. And this also gives us an opportunity to invest in our development instead of solving problems. And there are many other benefits. But since this is an inspirational speech, I want to share a very personal story. And this is probably the first time I'm doing this in my life. So please be forgiving and understanding. Maybe if the story that has happened with me has not happened, maybe I would not be here, maybe I would live somewhere abroad. But this is a story of how I joined Schwenk Latvia. Then it was a part of the other group, but value-wise we have kept the best. So it was 2008. I started working in this company, mostly due to the fact that I have studied the code of ethics of this company, its various policies, including what concerns human rights. I believed in these policies. I got the job and I started working. I was still in my it was still maybe a month or two after I had started working. And for many years I have been a human rights activist, starting from 2006. I have also organized Riga Pride and in various strategic litigations what concerns same-sex couples and the respective regulations. And so we went for lunch with these two colleagues, and we are just having lunch, and one of the colleagues just started speaking derogatory about homosexual men, and it was very rude, and I was so shocked. It was not directed towards me, but at that moment I felt so bad. I was young and unexperienced. I had never seen situations like this, and I started crying, and I just got up and said that I cannot listen to this. I felt that it has also somehow denigrated me, and I thought that I have to go to the chairman, and I went to the office and I told about this, and I said that we cannot do like this, we cannot live like this. And the situation was solved in a way that he listened to me immediately. He invited this colleague into the office, and it was solved just in a few minutes, even without using this resolution mechanism. The chairman could have said, that we will do that within a month, and we will use this official procedure and so on. But it was solved just in a few minutes, and I realized that what they told is a reality. And I have seen that these values are really alive. If there is a code of ethics, we should use it, and only then the things will happen. And when you allow the people, when you let the people to trust that it really works, believe me, you will never see this kind of loyalty somewhere else. And I wish all of you loyal employees.